Hello, my name is Annie Koloko. Welcome to our immigration channel. And today we will be talking about a motion to stay. And this is actually a case study, that we have for a client, and we just wanted to tell you exactly what is a motion to stay. A motion to stay, as you can imagine, is actually a motion that is filed with the court or USCIS, at this point within the court or either, ICE as well, where you're asking for the stay of removal. Meaning, to give you an example, is basically you have ICE, the Immigration and Custom Enforcement, ready to remove you from the United States, and therefore that's where the process starts, and then that's where the motion to stay enter. Now, the case study that we have involved actually a client of ours who is a spouse of a US citizen with a pending I-130 application. Pending I-130 application is basically an application that is filed by either a US citizen or a lawful permanent resident on behalf of their family member. And it could be a spouse, it could be a parent, it could be also a child. In this example, it was actually she filed it on behalf of her husband. And when they came to our firm, it just happened that the case was still pending, and the client had another case that was pending before the BIA, which is the Board of Immigration Appeal, meaning that once a case starts and actually a foreign-born citizen find themselves in immigration court, it means that the government, the US government, represented here by the Office of the Chief Counsel, or either and also Department of Homeland Security, meaning they come in front of a judge and then they submit what is called a motion to, obviously a notice to appear, where they state and saying, okay, these are the reasons this person should be removed from the United States. Obviously, you, as the foreign citizen, if you're in court, you have the right to protect yourself, right? You protect yourself by obviously presenting a defense. Now, let's assume that you lose in front of the judge. It means that what you're going to have, you can have the right to go to another judge. And this is where we have the Board of Immigration Appeal actually entering the process. The Board of Immigration Appeal is actually located in Virginia. You don't have to show there in person, neither your attorney if you have one, but all of the process actually is done in writing. Now, if the Board of Immigration Appeal agree with the immigration judge and say that no, this individual should be removed, that the government has actually proven their case, then it means that at this point, you will have the case, actually, the foreign citizen will receive what is called an order, a final order of removal. And once you receive a final order of removal, it means that then Immigration and Custom Enforcement have to enforce, thus the name, they have to enforce the order and start the removal process. And that's basically where this client found himself when they came and consult with our firm, meaning that they had a final order from the Board of Immigration Appeal telling them, then you have to be removed from the United States. Then Immigration and Custom Enforcement actually issue a notice to the client asking them to appear on a certain date. And when you receive this notice, it means that you have to come with your passport, in order for ICE to be able to remove you. Then obviously you can imagine the stress, the client has a family here in the United States, the client has children. Then at the same time, there was an I-130 application that was pending, meaning that if there is an I-130 application pending, then maybe something could have been done. It was a very, very stressful. Why? Because it was under a very short time constraint, meaning that we had to gather document, not only two type of set of document. One, show that there was an application pending. In this particular case, the I-130 application was approved, meaning we have to submit the notice of approval. And then you also have to submit also the green card application. Everything has to be put together for the judge to see that this case actually can be reopened and closed in order to have the client move forward and get his green card. Meaning that's what you're trying to do. You're trying to file the motion to reopen. But the problem is when you file a motion to reopen before the BIA, the point because the BIA is the last court that had a decision on the case, that's where you always go where the last decision was rendered. In this case, the last decision was rendered at the BIA level. But it takes a while. Sometimes it can take more than a year for the BIA to actually issue a ruling on the motion. Then what's going to happen? Because in the meanwhile, ICE has to enforce the removal order. And then by also enforcing the removal order, it means that the client has a chance to find themselves out of the country while waiting for the decision of the BIA, which was extremely distressing for the family. Now, that's why we have to file what is called a motion to stay. And a motion to stay is basically another type of motion where you're asking the BIA, you're asking ICE also to stay removal, that's why that's the name, to stay removal until the BIA actually rule on the primary motion, the motion to reopen. This is extremely hard. It has a very low approval rate. Why? Because you really have to show certain things. It's not sufficient to say, oh, I have a family in the United States. I will miss them. It will be very hard for us to be separated. Unfortunately, that is not enough. Number one, you have to show that you have an application that is pending because there is no reason for ICE to delay removal if you have no relief actually for you even to become a permanent resident. Meaning, number one, you have to show that, yes, you have an application that has been approved and you just need the case to be reopened in order for you to move forward and have your green card. Meaning that's the first step. But that's not sufficient. Then the other step as well is that you have to show that your family and his family will actually irreparable harm through, obviously, either their spouse or either their children, right? And in the case of this client, his wife actually will be the one that will experience irreparable harm. Why? Because he was the primary, provider. The wife was at home with the children. But even beyond that, that is not sufficient. The wife also was the primary caregiver for her own father, also a US citizen, who actually has been diagnosed with a chronic mental illness, meaning the father was unable to survive on his own. The father needed actually full-time care. Now, the argument that we presented was to show that if now the wife, the spouse, had to go back to work on a full-time basis, she will not be able to provide care to her father who actually needed this care. Obviously, again, those statements are not sufficient when you're trying to actually provide evidence and submit argument for a motion to stay. You have to also have something, a statement that support your argument. And we had letter actually from the father-in-law of our client, from the physician, the people in care of the father actually supporting our statement. What does that mean? It means that in the letter, they did actually, they did mention, right? And that the father-in-law has been diagnosed with a severe mental illness. They also stated that the father-in-law was unable actually to take care of himself, that the wife and the client were the primary caregiver providing assistance to the father-in-law. That if now the situation at home change, meaning in this instance, the client will be deported from the United States, that will create an extreme and irreparable harm to the spouse and also to her father, because the father will deteriorate because he will have no one to take care of him. The children also will be affected as well. Meaning that we presented all of that and we submitted that to the court, obviously to the Board of Immigration Appeal and to ICE. And let me tell you, this was not easy, because once you present a motion to stay to ICE, it has to be done in person. It's one thing to mail it to the BIA, to the Board of Immigration Appeal, but when it comes to ICE, no, you have to get there. You have to have the 155 filing fee. That has to be a money order, a postal money order, and you have to show up at ICE headquarters and make sure that you're there probably before 2 p.m. because it takes them about 1 hour to process the whole application. We did that, and now we just have to wait for, obviously, the officer, the deportation officer, the ICE headquarters to make a decision on my client's case. And great news, yesterday we received an email from the deportation officer letting us know that the motion to stay was granted, and it was granted for 1 year. And 1 year is actually the maximum time, meaning that we bought 1 year reprieve for the client. He was extremely happy because he had been so stressed out, and we are very happy because obviously, we see how it can affect family. And now, in a year, if a year from now, the BIA has not decided, which probably is probable, right? Because it takes a minute. Then what we're going to have to do is to actually resubmit another motion to stay, obviously, resubmitting the same argument and waiting for the BIA actually to render the decision. But that's basically an example, and this is a case study of what is considered what we call a motion to stay. And that's a very important tool. What I want you guys to remember from this video is that sometimes you do not get discouraged, because when we started working on this case with the client, it seems on paper that there was nothing that would show irreparable harm, right? But sometimes you have to really be open and disclose everything to your client, because when he started talking more and more, that's where we noticed that, he was the caregiver for his father-in-law alongside his wife. And that was actually the key, meaning that you never know in your life what will be the key, what will be the argument that will actually render your case successful, increase the success of having your motion to stay or a motion to reopen, or either a cancellation of removal. Meaning we'll be talking, I will be giving you example in subsequent video, but I just wanted you to give you an example of how, working in synchronicity with your attorney can definitely increase your chance. My name is Annie Koloko. I am an immigration attorney, and please make sure that you follow this channel where we talk about immigration news, and also we talk about immigration law and case, and we want to make sure that you guys are empowered and that informed in order, your right, in order to be able to live and settle in the United States. Thank you. Be safe. Goodbye.